court judges used when they ordered the states where the cases came before them, to authorize and recognize same-sex marriages. One is that marriage is a fundamental liberty. That is, it's in the same category as speech and press and religion and travel. And you don't need a government permission slip to exercise a fundamental liberty. The other is, the more popular one used by the lower courts, is the Equal Protection Clause of the 14th Amendment, enacted after the Civil War in order to correct the errors of our pre-Civil War society, to require the states to treat similarly situated people in a similar way, thus saying if a state offers marriage, the privileges and advantages of marriage to straights, it must offer them to gays. In fact, Alabama, in order to remove itself from this, for a couple of weeks, stopped marriages of opposite-sex people so that they didn't have to afford them the same sex. Instead of picking one of these two theories today, the court relies on both. That means that from and after today, the right to choose a mate is a fundamental liberty, the highest category of liberty that we have, one that does not require a permission slip in any respect from the government. It also means that when the government offers a benefit and advantage of any nature to a person who is straight, it must offer the exact same benefit and advantage to a person who is gay.
So conceivably, this has far-reaching implications way beyond simply same-sex marriage.
Yes, it does. It also means that those marriages that were in limbo, those 2,000 marriages in California that first were made lawful and then were made unlawful, those marriages that were in states where it was against state law, but the federal judges ordered them to do it, all of those marriages, as of 10 o'clock this morning, are valid and subsisting, and same-sex marriage is now lawful to be performed and to be recognized when performed elsewhere in every state in the Union.
And are required to be performed.
Yes, in every state in the Union.
Stunning. As we're looking now at the Supreme Court, there were a lot of folks who are very excited, and we're now just beginning to dissect the opinions themselves. And Shannon Bream so aptly pointed out that what we saw yesterday from Chief Justice Roberts, when a lot of folks said that he was making law and that this was the court legislating things, now says that it is not the Supreme Court's job to say what the law should be. I'm wondering, as you read through this from a legal perspective and you read through the decision, what's your takeaways?
Well, it's 103 pages. In a few minutes, I'm going to go off air.
And you couldn't get through that in 13 minutes.
In a few minutes, I'm going to go off air and read all of it. But I've gleaned the important points, and I appreciate the opportunity to make them. And I'm not going to question the Chief Justice's motivation, but it does sound like two different people. He basically is arguing today that marriage is regulated by the states. It's been regulated by the states since 1789, and the federal courts should have no position telling the states how to regulate something that traditionally and consistently has been regulated by them, and it should be decided by the popular branches, and the judges shouldn't even be reviewing it. Why he did what he did yesterday is between him and his heart, we will never know. What he did yesterday is reprehensible in my view, because if they can declare words ambiguous and redefine them, they can turn yes into no and no into yes. But the dissent of Justice Scalia, as ferocious as it was yesterday,
was nothing compared to
was a Christmas card compared to his dissent today, in which he accuses the court of being egotistical, of engaging in a judicial putsch. That's the phrase used to describe Nazi takeovers of lawful government in Germany at the end of the Weimar Republic.
Have we ever heard, or I should say read, words like this in Supreme Court dissents?
No. I told Bill Hemmer yesterday that of all Justice Scalia's dissents, and I've read all of them, and full disclosure, he and I have socialized together, and we have also presented professionally in law school environments together, but I had no knowledge of this at all. So I like him as a person, though as many times I disagree with him. But his dissents are articulate, forceful, and compelling. Yesterday's was the strongest I had ever seen. Yesterday's pales in comparison with today's. He basically is saying 5 unelected black-robed judges have taken over the government, have rewritten an institution that's 4,000 years old, an institution that relies on popular consensus and ancient tradition, and there is no authority whatsoever in the Constitution for them to do so. If I may, hubris is sometimes defined as overweening pride, and pride, we know, goeth before the fall. The judiciary is the least dangerous of the federal branches because it has neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm and the states, even for the efficacy of its judgments. With each decision of ours that takes from the people a question properly left to them, we move one step closer to being reminded of our own impotence.
Well, we don't have to, we nor history will have to worry exactly what Justice Scalia thought. Judge Napolitano, appreciate your insights.
You're welcome.
Thank you, sir. Martha?
Very strong statement here from Justice Roberts as well, as we start to dig into some of the language of what he had to say in his dissent. Shannon Bream joins us live from the Supreme Court. Shannon, very interesting language here from the Chief Justice.
Yeah, there was. And as the judge was just talking about Justice Scalia and his dissent, he's right. It is even more on fire than the one we got from him yesterday. He says this opinion is couched in a style that is as pretentious as its content is egotistic. He rips the majority, not a surprise. Something interesting, though, we saw in the majority opinion written by Justice Kennedy. There's been a lot of concern about what would happen to people who have religious objections if this court found in favor of same-sex marriage. He writes, this is Justice Kennedy in finding same-sex marriage for all 50 states. He says, it must be emphasized that religions and those who adhere to religious doctrines may continue to advocate with utmost sincere conviction that by divine precepts same-sex marriage should not be condoned. The First Amendment, he says, essentially protects them. But of course, we're waiting to see one of these cases filter up here through a florist, a baker, a photographer, somebody who objects to taking part in a same-sex marriage. We've seen a number of those cases in the lower courts. It seems after today, it's almost destiny. One of them will have to be decided here to see how far the protections of religious freedom will or won't go. Martha?